So, Ari, an incredible 2 weeks in terms of voting rights, and it couldn't come at a more opportune time for your book to be released. Again, I should say you're in soft cover. The book, of course, Give Us the Ballot. You are one of, in my estimation, one of the foremost experts at this point on the Voting Rights Act in this country, and what we've seen over the past 2 weeks doesn't take us all the way there, but it is a very strong statement, at the very least, of what the circuit courts believe was the Supreme Court's actions in gutting parts of the Voting Rights Act. Let's start in North Carolina, because this was the most egregious set of laws passed that undercut North Carolinians' right to vote that existed before these laws passed. I mean, explain what I mean by that.
Yeah, so this has been a huge 2 weeks for voting rights. 6 GOP voting restrictions have been blocked in a span of 2 weeks, which is really, really significant, including in very important swing states like North Carolina and Wisconsin. And the North Carolina case was so significant because, as you mentioned, the state did pass the country's most sweeping voting restrictions. They didn't just require strict voter ID. They cut back on early voting. They eliminated same-day registration. They eliminated out-of-precinct voting. They eliminated pre-registration for 16 and 17-year-olds, and they did so just a month after the Supreme Court gutted the Voting Rights Act and said that racial discrimination in voting was largely a thing of the past. So that meant that North Carolina became really a national poster child and a symbol of what happened after the gutting of the Voting Rights Act. And then the Fourth Circuit just stepped in and said that this was intentional discrimination against black voters, that the North Carolina legislature requested data showing that African Americans were more likely to use early voting, were more likely to use same-day registration, or more likely to not have a voter ID. And at that point, then they cut back on all of those methods and added new restrictions that would specifically target African Americans, in the words of the Fourth Circuit, with, quote, almost surgical precision. So it was both a huge victory for voting rights and also a really remarkable statement by the Fourth Circuit about what North Carolina Republicans were doing.
And so the one of the aspects of this ruling that were so important and is that, and because I know there are people who are listening to this interview and saying, well, wait a second, how come we don't have these type of opportunities to vote in my state? We don't have maybe early voting, or we don't have Sunday open polls, or et cetera, et cetera. And that's what was so important about this ruling, right? Because it was not measuring the right to vote against some, I guess, vague standard. It was measuring it based upon what existed prior to the imposition of these new laws that took away existing rights.
Well, absolutely, and that really should be the standard, because people in North Carolina don't know what the voting laws are in other states. They only know what they had before. And when you eliminate same-day registration, when you eliminate a week of early voting, when you require strict ID, these are all changes that make it harder for North Carolinians to vote. And the court decision laid out a very clear narrative, which is that beginning in 2000, North Carolina took a bunch of steps to increase political participation, including things like early voting and same-day registration. This benefited everyone broadly. North Carolina jumped from 37th in voter turnout in 2000 to 12th in voter turnout by 2012, but it particularly benefited African-American voters in the state who had been historically disenfranchised throughout the South. And black turnout and registration actually increased over white turnout and registration in 2008 and in 2012. It was at that point in time that the North Carolina legislature passed all of these new voting restrictions. And the Fourth Circuit, for example, pointed to the elimination of Sunday voting. And they said that the state said in court that African Americans and Democrats were more likely to use Sunday voting, and that's why it was eliminated. I mean, they actually admitted that, and that the court said that was as close to a smoking gun as you'll find in modern times.
And that is a specific quote, we should say. That is
specific quote, yeah.
And so the other aspect of that is that the idea that because we've had gerrymandering in this country for as long as we've had voting. And certainly there's nothing specifically wrong about gerrymandering. I mean, maybe there's something wrong about it, but nothing specifically illegal if it is done for sort of partisan reasons, right? I mean, or purely partisan reasons.
Yeah.
But this ruling suggests that because there is a partisan benefit does not mean that you can use that as a shield from the accusation that it's also racially discriminatory.
Absolutely. The court said that you can't just use partisan politics as a pretext for racial discrimination in voting, and that's exactly what happened here, that whether or not that black voters were discriminated against because they were black or whether they were Democrats, it didn't really matter. The net effect was that, as they said, North Carolina passed 5 different voting restrictions that uniquely targeted African-American voters in violation of the Voting Rights Act. And I should add that if the Supreme Court had not gutted the Voting Rights Act, and if states like North Carolina still would have had to approve their voting changes with the federal government, this law would have been blocked to begin with. So there would have never needed to be a trial in the year 2016 because it would have been blocked in the year 2013. And not only that, I don't think North Carolina would have even passed this law to begin with because I think they knew that it was going to be blocked by the Department of Justice. And indeed, all of these things like cutting back on early voting and eliminating same-day registration, this was all only thrown in the bill they were considering after the Supreme Court gutted the Voting Rights Act. And in the words of one North Carolina legislature, now we can go with the full bill. So this was an agenda that they only were able to do because the Supreme Court gutted the Voting Rights Act, and it took years of litigation and people being disenfranchised in the meantime to stop it.
And the other aspect of this North Carolina case is the sort of the flip side of it. On one side, it's like they've clearly targeted black voters. And they can't use the excuse, well, the only reason why we targeted black voters is because we want Democrats to lose. That doesn't excuse you from targeting black voters, which is what I think North Carolina was basically trying to argue, at least on some level. But the other argument that fell short, I mean, distinctly, and it seems to me that the sort of the size of the failure of these arguments contributed to the court's finding that there was racial intent here, or racially discriminatory intent, was the argument that the state had a compelling interest to deal with voter fraud. I mean, talk about how sort of relentlessly and brutally the court rejected that argument.
Well, that was really a key part of the argument against not just the voter ID law in North Carolina, but in Texas as well, which did a similar thing, which is the court said that North Carolina required strict forms of ID for in-person voting, but not for absentee voting, where voter fraud is far more common. So voter impersonation is virtually non-existent. Absentee voting, where there's fraud, is a little bit more common. It's still not prevalent, but it's definitely more common than in person. But North Carolina required ID for in-person voting, which blacks and Democrats are more likely to use, and didn't allow it for absentee voting, which white voters and Republicans are more likely to use. So, in fact, under the quote-unquote guise of trying to stop voter fraud, they actually made voter fraud more likely, which is why the court didn't buy North Carolina's justification for the law.
Ari, let's take a break. When we come back, let's talk about the other 5 cases over the past 2 weeks that are so relevant in terms of our right to vote in this country. And I want to talk about what happens next and why this is happening now in these circuit courts and if it has something to do with the death of somebody that somehow his death keeps resonating in a, with all due respect, a good way. We got to take a quick break. We'll be right back with Ari Berman. So, Ari, when we broke, you had just basically outlined for us the Fourth Circuit's ruling on a whole set of laws that was imposed by the state of North Carolina. I think it was back in 2013, was it? Or was it more or less, which restricted North Carolinians' right to vote. The Fourth Circuit found that these laws were discriminatory, racially discriminatory in their impact, but also in their intent. and that there was very little justification for these laws, and struck them down. But what they didn't do was say that we're going to force you back into a pre-clearance regime. Explain what's behind that. I mean, this goes back to the Roberts Court, Supreme Court, dismantling an important function of the Voting Rights Act.
Yeah, so basically what happened is the Roberts Court in 2013 said that those states with the worst histories of voting discrimination no longer had to approve their voting changes with the federal government. There still is a little used part of the Voting Rights Act that says that if you're found guilty of intentional discrimination in voting, you can be, quote-unquote, bailed back in under the VRA and once again have to approve your voting changes with the federal government. This is something that might happen to Texas as a result of their voter ID law being ruled against. In North Carolina, the court said there was intentional discrimination, but they declined to bail them back in, I think because they blocked all of the challenge provisions of the law because it was such a strong finding. They didn't want it to be overturned on appeal. That's my guess about why they did what they did there.
Practically speaking, how does someone get bailed back, or not someone, how does a state or a county get bailed back in? Does a court have to order that? Are there a separate set of procedures that the Department of Justice could follow? Could they bring up could they sue, let's say, in federal court to bail North Carolina back in based on this ruling?
A federal court would have to do so. It seems like it's off the table right now in North Carolina because the Fourth Circuit declined to do so. In Texas, the Fifth Circuit there ruled that the lower court, which did find evidence of intentional discrimination, basically has to hold another trial after the election to figure out if Texas is going to be bailed back in. So this is a very cumbersome tool that really only can be applied to the most egregious actors. And even if there is evidence of intentional discrimination, it's not clear that this bail-in thing would work. So one thing that the Congress could do, for example, is they could not just restore the Voting Rights Act, they could also make it easier for states that have been found guilty of discrimination to be bailed in and once again have to approve their voting changes with the federal government. That is something that Congress could do to strengthen the law.
Okay, so we had obviously Texas, you mentioned. We spoke about North Carolina. The other big case was in Wisconsin this past week. What was that case about?
Yeah, so Wisconsin, like North Carolina, passed not only a strict voter ID law, but a bunch of other under-the-radar voting restrictions, like making it harder to cast absentee ballots, harder to register to vote. My favorite is they eliminated early voting on nights and weekends, which is when it's most convenient for people to actually vote if they're going to vote early. These things were also struck down. The voter ID law was basically softened because it had already been upheld by a different court, but basically they said that they have to allow more IDs, like student IDs, and also allow those who don't have IDs to vote with something like an affidavit instead of showing ID. And then they struck down all these other restrictions that were more under the radar. And like in North Carolina, the federal court in Wisconsin said that particularly cutting early voting was something that was done to suppress the votes of African-American Democratic voters in Milwaukee. So, I mean, we had decisions that happened the same day, North Carolina and Wisconsin, where the court used basically the exact same language that Republican legislators had been intentionally discriminating against African Americans for their own political benefit.
And so, I mean, when we talk about Wisconsin, we talk North Carolina. I mean, I want to get to three of the other in Texas. I want to get to North Dakota, Michigan, and Kansas in a moment. But I mean, how many voters are we talking about that are now going to have easier access to the right to vote?
I mean, collectively, millions of voters, and in each state, hundreds of thousands. You look at Wisconsin, for example, 9% of registered voters in Wisconsin didn't have strict forms of government-issued ID. Hundreds of thousands of people voted early. In North Carolina, hundreds of thousands of people voted early, used same-day registration. So these are really, really big steps that make it easier for people to vote, that allow all of the different groups to focus on getting people out to the polls, not striking down bad laws. And that was one of the things, is that so much effort was spent just trying to strike down barriers to the ballot box that there was really no energy left to try to get people actually out to the polls. And now that's what we can focus on. We can focus on making sure people vote in November instead of having to comply with all of these ridiculous hurdles that there was no justification for.
And part of the effort has to be just to let people know that those barriers are not there, because you have a lot of people who are assuming that they can't vote when they actually can.
Yep, and states like North Carolina, Texas, and Wisconsin have done a terrible job of getting the word out. And it's going to be particularly important in Texas and Wisconsin.
And do you think that's a mistake? Do you think that's a mistake? I mean, of course the states do.
Of course they did. No, I mean, the Wisconsin's voter ID law required a public education campaign that the Republicans then didn't fund. Not only did they not fund the campaign, they dismantled the agency that oversees Wisconsin's elections on a nonpartisan basis. I mean, this is a pretty transparent strategy. And so the fact that in places like Texas and Wisconsin you can now vote without strict forms of ID, people need to be aware of that, so that they don't not show up because they don't think they can vote in the first place. I'm very concerned about people being aware of these decisions and what they really mean.
All right, we just have 2 minutes left, so we may not get to the specifics of the North Dakota, the Michigan, and the Kansas holdings. But so right now we have the Fourth Circuit, the Fifth Circuit, the 10th Circuit, the 7th Circuit, and the 8th Circuit, all coming out with rulings in the course of a couple of weeks, basically rebuking the fundamental premise, it seems to me, of John Roberts and the Supreme Court when they said we don't buy the formula for preclearance. We don't think, broadly speaking, that the Voting Rights Act is as relevant as it used to be. What's going on here? I mean, are these circuit courts, are they taking more license? Are they emboldened in some fashion by knowing that Antonin Scalia is now dead, and it is a 4-4 tie on the Supreme Court, and perhaps coming down the road we may see the balance of power on the court shift?
Yeah, so I think what the courts are realizing is that they're likely to be the final word on these issues, so that their opinions really do matter, and they have to get out their opinions well before the election so people are able to vote. And I think that's why we saw all of these things happening in late July, early August, because now it gives states 3 months to do the voter education necessary, and all of the non-state actors to do the voter education necessary to make sure people are able to vote. I also think what you're going to see, particularly if the 4-4 deadlock court becomes a 5-4 center-left court, if Merrick Garland or some other Democratic nominee is confirmed to the court, I think you're going to see voting rights groups be more aggressive in challenging voting laws elsewhere and trying to get the Supreme Court to give a stronger interpretation of the Voting Rights Act, to give stronger protections in the Constitution so that more of these laws can be struck down going forward. It's not an excuse for Congress not to act. The best thing for Congress to do would be to pass new laws that make it easier for people to vote, to restore the Voting Rights Act. But in the absence of that, it's certainly true that the lawyers and the courts can be more aggressive in challenging these laws.
Ari Berman, your book, Give Us the Ballot, comes out in soft cover this week, and couldn't be more timely. Thank you so much for your time today. Really appreciate it.
Great to talk to you, Sam. Thank you.